I
Yes.
No.
no.
What? No,
No.
that's not possible. Hold on, let me get my register to make sure I have my emails correct, which I know I do. Who's saying no?
Colette. Who's
Hold on. Let me look for where I put my list. No one got it? Doris, did you get it?
I don't remember getting it. No.
No, I just did it a little while ago.
I got it
Oh.
522.
Oh.
Yes.
Oh. Okay.
Yes. Because remember, I said we were going to do it in class, but now we're gonna have to do it remotely. It won't be that difficult.
Okay.
I didn't get an email.
Hold on, let me do a register first for Miss Dean. I see Doris is on.
I got it.
Okay, Colette,
Yes, ma'am.
you didn't get it?
Yes, I got it. Yes, ma'am.
Okay, all right. Veronique, you got yours, right? Because I know I sent it to her.
You send it to me?
Veronique?
Yeah.
Yeah, you didn't get it?
I'll check now. I'm already at this. I didn't check anything.
So it's hope. I got an email, but also the first email said Mondays, Zoom, Wednesdays.
I'm not talking about that. I talk about
What-
email from me.
Mondays, coming in person.
From you. Okay, let me check. Okay, so what's your name again? Okay, so Waltine is about to sign on as well. Oh,
Waltine should have hers.
Half an hour.
okay. So she said she doesn't have data right now to find out. But I got
Okay.
it. I got your email.
Okay, so in attendance is Doris, Colette, Veronique, McQuell, and Waltine.
Yeah, also Tia was also here as well. She's just waiting on me to send her the link.
Oh, what's her name?
She said her name is Tia.
TIA.
Yeah, she said she missed the last class, so this would have been her first class. No problem.
Veronique, Waltine, Nikiva.
Oh, I don't know. Unless she said Kiva, I don't know.
Okay, Colette is on, Doris is on, Ashley isn't on. And Anwar Curry, no. Tonya is not on.
If you send that to the work email, they probably, they would already signed out. God no.
Oh, well, that's
Yeah.
the email they gave me.
Because I need to give you my personal email. I'll probably send it to you.
Okay, all right, let me see. Hold on, let me search what I sent to you, what I sent yours on, Doris. Yeah, that's your work email I have. Hold
Yeah,
on.
I was already offline. Okay.
So let me go here. Here. I hope you get all of these. Okay. Send. Do a forward. Okay, what's yours, Doris?
It's DOR
Uh-huh.
JACK
Mm-hmm.
08 @gmail.
Okay. Let me put that in. DOR JACK 08
Yes.
@gmail.
Yes. Thank you.
Okay. And who else I send at their work? Natonia. She's not on, right?
No.
So I don't have her. No, I don't have hers. Okay. You should have yours now, Doris.
Okay, checking now.
Mhm.
Yeah, I just got it. Thank you.
Okay, good. All right, so 1, 2, 3, 4. 1, 2, 3, 4. Those come out. Okay, all right. So the first question, we could do it two ways. We
I didn't get
can,
an email. Sorry.
Oh, who's that? Who's that?
It's McQuell.
Mm,
McQuell Nabi. I don't think
no, I don't.
Hmm?
What's your email?
Nabi McQuell at outlook.com.
Hold on. Spell.
NABB
Uh-huh. E M.
IEMCQUELL
Okay.
at outlook.com.
Oh, Outlook. Okay.
Mhm.
Okay. Forward in the same email. NABBIEMCQUELL at outlook.com. See. Okay, you should have it any minute. Yes?
Not yet. Okay, yeah, I have it now.
Okay, good. Okay. All right, so the first thing you see in the email is the question that I told you we would do tonight, which is a pure contract law question, just for you to get an understanding of the basics of contract law before we move into the banker-customer relationship. So have a look at the question, and then we will discuss how you are going to approach it. I'll give you a couple of minutes to read it. Let me know when you're ready to start. And the second message after the question is just general contract cases. Okay, we ready? Or still reading?
Still reading.
Still reading.
Which one
Okay.
are we doing first?
The very first email. The one with the sale of the car.
Oh, okay.
That's the one we're going to do first.
Okay.
And I remember in law, whenever you make a point, you have to refer to a case.
Oh,
Yes. So the second email, I've given you some cases.
okay. I was reading them. I'm trying to figure that out.
Oh, you're reading the cases, eh?
Yeah, I was reading them.
So for the midterm, everybody ready now or not? I should wait for me. I should wait. Wait a few more minutes.
I
Yeah,
read the
good.
case. Give us
Okay.
5 more
All right.
minutes.
So for midterm, I will give you all a pure contract question to do, just to make sure that you understand the principle. That pure contract question will not be on the exam when you go to take the midterm exam. You will bring it to the exam with you, or you can email it to me.
Mhm.
Because for this class, you don't have to memorize pure contract cases. So you'll be able to use the cases in the link and answer the question. So that question you have it as a take home.
Okay.
But when we go, after we finish this and we start the banker customer relationship, you have to know those cases in your head, which means you have to look them up and you have to understand what they're saying, what are the principles and what are the facts. Everybody understands?
Yes, ma'am.
Okay. So when I forward you your one question that you must do at home, it is a pure contract question. And then you could send it on the day of the exam, either electronically, or you could bring it to class and have it stapled to the whatever you do in class. So, okay, so now let's begin. Remember what I told you, when you answer any law question, you have to look at what are the facts, what are the issues, the law, and then of course, your analysis. So let's start. Hold on. This is a student. Why is she calling? She was on the link. I wonder why she calling. She was on the list.
She might have
She
gone
can't
off.
say yeah, I don't know why. She hung up though. Okay. So what's the facts of this case?
I finished reading. Yeah.
Oh, okay. Read it first.
Give me 2 more minutes, please, if you don't mind.
Okay. No problem.
Okay.
Okay, one, David had advertised to call 500 for a quick sale.
She's calling again. Let me see if I can answer her. Okay, she actually went to school instead of signing in.
Okay.
See if I could find her. She sent it to me in a chat. Right here. Okay. All right. Okay, Doris, you ready now?
Yes.
Okay. Doris, you ready?
Yes, yes.
Okay, I sent it to her. Okay, she has it. Hello?
Yes. Hi, can you hear me? Oh, sorry. Can you hear me?
Yes,
Hi.
Doris, I couldn't hear you, you know.
Oh, can you hear me now?
I can hear you now. That's my phone. It went down. Okay, so we ready?
Yeah, we're ready. Yes.
Okay, so what's the facts? Anybody?
But the fraudulent act was, there was a fraudulent act.
Why you say it's a fraudulent act? You can't
I mean-
come to a conclusion.
Oh,
the
Okay.
facts of the case is he advertised the car for $500. A quick sale, best offer secures.
they don't know.
Mhm.
I look at the wrong case. I must have read the wrong case.
Which one you reading?
I thought you said the first one, the Mrs. Ingram, you want to use
No,
that.
that ain't the first one.
Oh, but that's the first one on my thing you sent me. I'm sorry. Okay, sorry about that.
Go
Two,
back
mine,
to the-
two, that's the first
Oh,
one.
that's why you was taking a little while. No, the first
Yeah.
one is David advertised his car for sale.
Okay, okay, no. Sorry about that.
So
I read-
Eric-
That's okay.
Eric viewed it, and David told him that he has until Friday to decide, to let him know by Friday.
Right. And
Frank
what else?
also, so after returning home, he sent a letter to say he agreed to buy the car. For the
For
550.
500, for the
Yeah, for
500.
500.
Mhm.
Right.
But then he showed up with 250.
Yeah, and then Frank looked at the car, but Frank said he didn't want it anymore. That's nothing.
Okay. So normally when you do any legal question, the first thing to do is write down the facts. Because what you're going to do is each one of those facts that you write down, the next thing you're going to do in part B is convert those facts into a question. So we start at the very beginning. Let's look at the first sentence. David advertised his car for sale. $550, best offer secures. Then Eric comes to look at the car on Tuesday, and he said he would give him £500 for it, but he let David know by Friday. So if we start with the first sentence, when he advertised his car, what is that in contract law?
Offer?
No.
Shoot, it's an offer.
No. He advertised his car in a newspaper. Remember, an offer can be an actual offer, can be an invitation to treat. That is an invitation to treat.
Right.
Okay.
He's asking anybody who is interested to come and have a look at the car. It's an invitation to
Okay.
treat,
I
right?
gotcha.
Mhm.
Okay. So invitation to treat, if you look at your law cases, that could be, oh Lord, the case right in front of me looking at me. Pharmaceutical versus Boots. That could be Patras versus Crittenden. These are all invitation to treat cases. Now you can also argue on the end offer. I'm saying because he put the hyphen, he put best
Mhm.
offer secures. You can argue that it was not an invitation to treat, that it was an actual offer.
Okay.
So the question you're gonna ask yourself now is whether the offer, Eric offer 500, when Eric offers the 500 pounds for the car, now, you agree, right?
Correct.
Right.
Uh-huh.
So what has to be determined now is whether this offer has been accepted by David. So that's your first question. Is whether David has accepted Eric's offer of 500. Now, David does what after that? David posts a letter to Eric
Agree.
accepting the offer on Thursday.
Mm-hmm.
I remember we discussed the postal rule. How does the postal rule work?
I mean, once you send it to the person's mailing address,
Mhm.
that means it was sent, eh?
Right. So right.
Mailing address, right.
Acceptance is the date on the postage stamp on the letter, as long as it went to the correct address.
Right. Okay.
And the case for that is Adams versus Linsell, Lindsell. And remember, I told you in the last class, whenever you're going to talk about how a response or how an acceptance should go to the offeror, you have to think about what was the method of communication that was agreed between the parties. So that's a discussion to post it. Now,
There
Eric
was no
made his offer
agreement.
how?
There was no agreement on how.
Right. So Eric offer was an oral one, right?
Right.
So you could argue that he expected an oral response and not one by post.
True.
So if we want to argue the next way and say, yes, there's nothing wrong with him sending it by post, what did Eric say? Didn't Eric say, let me know by Friday?
Yes.
Right. So that means that in order for David to say that Eric has accepted offered or that he accepts Eric's offer, it has to be done by Friday.
Right.
So that means he needs notice by Friday. And the case for that is Howell Securities. Howell Securities versus Hughes. So in this scenario, acceptance, the communication of the acceptance only occurred when what? Eric actually received David's letter. So when was the letter received?
Saturday,
Saturday.
And so what that means,
past Friday.
and what that means in contract law,
It's null and void.
no, the offer has lapsed.
Mm.
Oh,
Passage
okay.
time is lapsed. So that means
Oh,
there is no,
So there's
Go
no more
ahead.
offer on the table then?
exactly.
Okay.
So there's no contract between David and Eric. So what happened when Eric now comes and offers 250?
David could refuse. He's correct.
You got it. Yes.
He's correct then.
Yes.
Offer finished.
Right.
So the contract expired as of Friday midnight. So
The
therefore,
offer,
anything,
the offer.
yeah, the offer, sorry, the offer expires, it's just like a contract. If you give a date. So for
Mhm.
instance, if I say, I want to sell my car and I sent it out at 5 p.m. on Monday, and I said the offer ends Friday, 5 p.m. That's a contract, or
No, that's not a contract. Don't mix up the words now.
no,
That's-
I'm asking.
Go ahead.
So is that a contract or an offer?
That's an offer.
Okay,
Don't forget, to have a contract, you need all of the elements. You need
Okay.
offer, acceptance, consideration, intention to create legal relations, and capacity. All of those things to say you have an actual contract.
But David, in the event that it wasn't after Friday and he still brought the $250, David still agreed to $500.
No, say that again.
Okay, Eric didn't receive the letter for $500 until Saturday. That lapsed because it was past Friday, the agreement date,
Right.
right? But then
Mhm.
Eric came to the house with $250.
Yeah, but his fresh offer would have still been after,
But what if it was, say, Friday and he came with $250? Then it's not valid, right?
Right on, don't say not valid. If he had come with the 250 on Friday,
Mm-hmm.
it still would have been the offer. Okay, start again. When the offer was made, David sent it out as an invitation to treat, if you want to argue the way, as an offer. He's selling it for $550.
Mm-hmm.
So Eric came and Eric said, I will give you $500.
Yes.
But he told David he'll get back to him by Friday.
Mm-hmm.
So if Eric comes back to David by Friday and offering $250, he is still late.
Okay.
The offer has lapsed.
Okay.
So you could conclude that between David and Eric, they don't have a contractual relationship. Now, what about Frank?
They don't have a
Frank
relationship.
examined the car on Wednesday,
Right.
and then he posted a letter saying he agreed to buy the car for $550.
And then he changed his mind.
But before David received this letter, Frank telephoned and told him he didn't want the car after all.
So again, they didn't agree on a mode of communication, so yeah, offer rescinded.
Okay, because let's start from the beginning now. We're doing Frank and David.
Mm-hmm.
So when David said he'll pay $550, what is that?
That's the
That's the
invitation.
offer.
An
Or the-
offer.
That's an invitation.
Could be either one.
Mm.
Okay,
So when Frank on Wednesday appears to offer to purchase the car for $550. And we know that offer can be revoked at any time before acceptance.
mm-hmm.
Mm.
So what did Frank do after he said the $550? What did he do?
He said, I
Because-
agreed to buy the car for the $550 asked by you.
But before David
But-
received this letter, Frank
Oh.
telephoned and told him he didn't want it anymore.
Correct.
So what does that mean?
The offer.
Frank had telephoned to revoke his offer.
The
Right.
revoked
Right,
it.
he revoked.
Mhm.
Right. So there was no contract between those two.
No.
Correct.
But
So-
I want you to go back to the wording. Frank says, I agree to buy the car for $550 asked by you. What does that mean?
He's entering into a verbal contract.
What he has actually done is he has said what? He's accepted.
Accept, yeah.
Yeah.
Even though he would have called afterwards to say, I don't want it anymore. His words was acceptance.
Yeah.
Mhm.
Oh.
You'd be very careful what you say.
Yeah.
Miss,
And the case you could use for that is Smith versus Hughes. Hughes.
so Ms. Archer, because he posted, because he put his offer in writing, I mean, shouldn't he have followed up in writing, declining the, I mean, rejecting?
We can
revoking
get to the
offer?
mode. We can get to the mode right now.
Oh, okay.
Yeah, we can get to the mode right now. Because he sent it his acceptance in writing. Okay, so if Frank's letter is an acceptance, the question is, just like Doris is saying, the communication now, it was sent by post.
Mhm.
So did the postal rule apply?
It should.
Yes, it applies. So if he used the postal rule, if he followed the postal rule where he agrees to buy it, then how does that affect his revocation of his acceptance? He posted his letter saying he agreed to buy it. And then what did he do? He
And then he
called to say,
called. Right,
aha,
so his revocation.
what does
should-
that mean? The question is this, whether a posted acceptance may be withdrawn before the letter has reached the offerer.
Mm,
Remember the rule and the postal rule now. Once you submit a letter, mail a letter, it is stamped and it has the correct address,
That's considered,
it's considered
yeah,
accepted.
yeah.
So what do you think?
I mean, in this case, I would think the offer,
What do you think?
I mean, I'm thinking the offer would still stand, eh? Because he didn't post the revocation of the offer. No?
But he called it in. What do
He
you
called
think?
it in.
So you know how law goes, right? The law says in the same case of Howell Securities versus Hughes, and they're saying that they will not apply the postal rule if it would lead to what they call or manifest to an inconvenience or absurdity.
Mm,
He posted his acceptance and then he made a phone call, which is faster than the mail.
right.
So he tried to intervene. before he got the letter to say, I don't want it anymore. So in effect, Frank's withdrawal of the acceptance is effective. So there was no contract between Frank and David either. So you have an idea now as to how to answer these questions. You have to go line by line and you have to ask yourself the question. And the question is always based on law. Do you want to try it for homework?
Yeah.
Or you feel comfortable with it?
No, I got to try this again.
I'd like to give it a shot for homework.
I
Okay.
like to try it.
Okay, all right.
Yeah.
Write it out. You can send it to me. And then let me see what's the best way. Hopefully on Wednesday we have in class, and then I'd be able to point it out to you on the board so you can see it.
Okay.
But yeah, write it out so I can see it. All right, now go to your notes, chapter 4. Now we're going to take the principles of contract law and we're now going to apply it to banking law. The first thing when you talk about the banker-customer relationship, you have to know what is a bank. And the case that is established what is a bank is the case of UDT versus Kirkwood. And it defined a bank as any institution that collects checks for customers, pay the checks drawn by them, have current accounts for their customers, and have a reputation in the community as a bank. Now, you also have to refer to the Banks and Trust Companies Regulations Act and see whether that piece of legislation defines what is a bank, and it doesn't. What it does is defines for you what is banking business. That's how our law is written. Now, the next thing you have to consider is who is the customer? And the court says that the customer is anyone who has decided to open an account. And that could be a rogue or that could be a legitimate customer. That could even be a foreign bank sending a check for collection in the Bahamas. They are also a customer. Always remember that banker-customer relationship is based on contracts. And those contracts follow the principal elements of contract law: offer, acceptance, consideration, intention to create legal relations, and legal capacity. In addition to that is all the other ones. Making sure there's no misrepresentation, that is in writing when it needs to be in writing, that is signed for a valid purpose. So the banker-customer contract begins when the customer's offer to open an account is accepted by the bank. So bankers, tell me when that happens. When is the contract done? When does someone become a customer of the bank?
When the customer opens an account and the bank agrees to, when the bank agrees to open an account on behalf of the customer.
Mm-hmm. What does that mean?
And they sign all the documents, the relevant documents, agreeing to the terms and conditions that is in the GTS and the forms that you would have signed to say all information that was given was that the customer gave and that you provided with them is agreed upon and signed by both the customer and the person acting on behalf of the company.
Mm-hmm. You still don't have a contract. You know Doris have a contract.
And then once that is open and they place their funds in their assigned account, that it's officially a contract.
Yes, now
Okay,
you get it.
because we
remember
can
what I
close
said.
it. Yeah,
Right.
because we can close it if they don't put nothing on it. After so many days or a day or within so many hours, it can be closed. So that's
Exactly.
not good. Okay, gotcha.
Right. So the banker customer contract begins when the customer offers to open an account and it is accepted by the bank. That is a process. The person comes in and said, I want to open an account. The banker then asks, what type of account you want to open? Then they say a personal account. Then the customer asks, what's the interest rate? Or what's the maximum I can deposit? They're going to ask you questions. Then they're going to say, okay, I'm going to open an account. You give them the form to complete. Then you review the form. Then you take it to whoever supervisors to sign off. So you have offer, you have acceptance, but you need consideration. And that's the funds to open the account. And you know that they have intention to create legal relations because they have said to you they want to open an account for a particular purpose. That's why you ask, what's the purpose of the account? That's the intention to create legal relations. And then capacity. When you get all the KYC documentation, you know that they are of a certain age, you know their nationality, and you know that I have all of the elements of a contract. And because it's a bank, it requires for every contract to be signed, physically signed. So it is in writing. So that's when someone becomes a customer of the bank. So in Woods versus Martin, it held that the bank may owe certain duties to a person before they become a customer of a bank. And that's when someone opens an account, but the bank has to receive the funds into the account. So that means that even though the funds are not in the account, because you know that the funds are coming to the account, that relationship is already there. And you'll see when we go to the other pages, there is duties and rights that automatically come when someone becomes a customer of the bank. If the bank provides advice to the clients, or even a person coming into the bank and asking questions, you have to be very careful. Because by you asking, by a customer or person asking a question and you providing them with an answer, and they rely upon that answer, and based on that answer, they lose money, they can sue the bank. And they can sue the bank under contract law and say that the bank was negligent because the employee didn't know what they were talking about and gave them incorrect information. So the implied terms of the banker-customer relationship are dependent upon whether the person is deemed to be a customer of a bank under common law. Remember, common law means case law. And the exception to this is someone merely cashing a check for a person who doesn't have an account with the bank is not considered collecting a check for a customer. That person is not a customer of the bank. And now you could see over time how the banks now say, if you're not a customer, you cannot cash a check. Because before they would have done that, but it is no longer allowed because of fraud. If a customer is considered a customer of the individual branch where he has his account and not of the whole bank, always remember that a customer is a customer of the branch in which they opened the account. Yes, you can go to any other branch and make a deposit or make a withdrawal, but certain matters have to be carried out at the branch where the account was opened. So a banker-customer relationship under common law is one, contractual in nature. I think I've hammered that in your head long enough. You should know the elements of a contract with your head. Banker-customer relationship is contractual in nature. Second thing, a banker-customer relationship is a debtor-creditor relationship. When a customer deposits his money into the bank becomes a debtor to that customer. And the customer becomes the creditor. So the money, once it is deposited in the bank, that becomes the property of the bank. The bank could do with it whatever it wants to do. The customer is only a creditor. And which means that once the customer makes a demand for his money, the bank is obligated to provide that customer with the funds if they are on the account. And always remember, a customer, when he comes for monies from the bank, that is what we call a demand. And you cannot tell the customer that you cannot provide them with the money that they're requesting for, unless, of course, the account has a lesser amount. The role of debtor and creditor is reversed when a client has a loan. So that means then that the bank now becomes what? If there is a loan to a customer, the bank becomes the creditor,
Yeah.
right? And the client becomes the debtor. So the banker-customer relationship is contractual in nature. We know that there's a banker-customer relationship. Third is there are certain express and implied terms. Remember, express means that it is written in the contract. Implied means it arises by common law, which is case law. The fourth thing is the third thing continued on. The implied terms of the banker-customer relationship, which is the rights and the duties of the bank and the customer, were outlined in the case of Joachimson versus Swiss. That is the case that you must read. Now, the next thing that you must know the duties of a bank and the duties of a customer. You must know the rights of a bank and the rights of a customer. And you have to start learning it now before you get mixed up. So let's go down to the duties of a bank. The bank has a duty to receive money and deposits from customer, because that's the nature of his business. The second duty the bank has is to collect and comply with the checks written on the customer's account. But that's only provided that there is adequate funds available or there's an authorized overdraft in place. Collecting and complying with checks written also means that the checks have to be properly drawn up and not forged or stale dated. Added to that, there has to be no countermand on the check, no stop payment. And of course, the Thursday paper, whoever's the supervisor should be actually monitoring this along with compliance. You have to make sure that the customer has not died, or that any court order has been made against your customer. So your legal department will always go to the Supreme Court listing and a Court of Appeal to see if there's any matter that's pending before the court that deals with any of the clients of the bank. So the first duty of the bank is to receive money and deposits from the customer. Second one is they have to comply with the checks written by the customer. The third thing is they have to repay the customer's entire money on demand upon the customer's written order at the account holding branch or at another branch, as long as it's during banking hours. Fourth, the bank has a duty to give reasonable notice before closing a customer's account, if it is in credit. You cannot close someone's account right away. You have to give them sufficient time to make alternative arrangements. 5, the bank owes its client a duty of confidentiality. The bank cannot disclose banking and personal information to a third party unless it falls under one of the exceptions in the case of Turnier versus National, Provincial and Union Bank of England. And there are 4 grounds upon which you can disclose information. One is upon compulsion of law. The second one is because it's in the public's interest. The third is the bank's interest. And the fourth is because the customer has given express or implied consent to do so. And we'll do confidentiality in a chapter all by itself and go into each one of these. The sixth duty that a bank has is it has a duty to provide a statement of account to the customer periodically and upon request. And the customer is not obliged to check the bank statement for errors or omissions. Now, we know from the time this case was done until now, what has the bank done? Who could tell me what the bank has done with regard to this duty?
I think they put it on the customer to report any errors within a certain period.
Right. So they have taken this common law duty and made it an express one with the caveat that you have a certain time period in order to let them know if you see any differences that they should be aware of. Okay. Now, for our Wednesday class, I'm going to send you a case that was done in the Supreme Court. And in this case, which we can discuss, this case is, let me see what they say. This person was a client of the bank. The client claim is against the bank is for damages arising from the bank's negligence and breach of fiduciary duty and contract between the banker and customer. They're saying that the bank failed to properly monitor the client's account, failed to provide regular monthly statements, and failed to prevent the issuance of an authorized debit card. As a result of the bank's breach of contract and fiduciary duty and negligence, failure to prevent the issuance of an authorized ATM card, and failure to properly monitor the client's account, the client has suffered loss and damages. Now, don't complain because this case is 79 pages long. Okay, but because it is a local case and it was just recently held.
I think I remember that with the reporter.
Yes.
Okay.
Yes.
Good for her.
Yes. So I'm going to send that to you all to read because it really shows you the banker-customer relationship and the duty that the bank has. And the court takes it seriously. Okay, and so the last one is the bank has a duty to exercise proper skill and care in carrying out the customer's instructions, and that's why you are in class now. Because the employees are the ones who have to ensure that the bank is carrying out the customer's instructions. In order to do that, you have to understand that everything in banking is based on contract law. So let's look at the rights of a bank. So that's the duty of the bank to its customer. Now let's look at what rights the bank has. The bank has the right to charge the customer a reasonable commission for fees and services. And you know, where we went through the Banks and Trust Companies Regulations Act, what did the section say? Let's see who remember. What did the section say about commission and fees? No one remembers?
Say it again, I didn't hear what you are.
I'm saying the first right of a bank is to charge the customer a reasonable commission for services rendered. And I'm saying under the Banks and Trust Companies Regulations Act, there's a section that speaks to that. I asked if you all remember that.
Is it that the bank has to make the customers aware of the
Yes.
charge?
That goes with the same right here. They have the right to charge for services and fees and commission. But the act also says they have to give their clients sufficient notice. The second right that a bank has, they can demand payment for loans or for overdraft charges. And now that we're electronic, what does the bank do? If your account is overdrawn, do they call you on the phone? No,
No.
they don't.
No,
They just automatically take it off.
right.
The bank has a right to exercise a lien over any customer securities deposited other than items held in safe custody. So you'd be very careful when you sign the contract with the bank, because I've noticed a lot of customers come back complaining, saying that the bank took money off this account and that account, or took this or that. They have to remember, if that clause is expressly written in that contract, the bank has the right to do so. The bank has the right to be reimbursed by the customer for any expenses or liabilities that is incurred on behalf of the customer when it acts on behalf of the customer as his agent. The bank has the right to return any unpaid checks where there are insufficient funds to cover, unless, of course, you have an authorized overdraft. The bank also has the right of set off, which is the right under certain circumstances to take a credit balance on one account and set it off against a debit balance in another account owned by the customer in the same right. And of course, the bank has the right to combine accounts. So look at the duties of a customer. A customer has a duty to pay, of course, fees. They have a duty to issue checks only if they have sufficient funds on the account, or they have an agreed overdraft. The customer also has the duty to exercise reasonable care in drawing checks to make sure that there's no fraud or forgery. And of course, the customer have a duty to advise the bank if they know of any forgeries. The customer themselves have rights, and that's the right for repayment of their funds that they deposited on demand. And remember, that demand must be in writing. They have the right to have the bank discharge its duties to the customer. They also have the right to have funds deposited, appropriated to a specified account to cover checks the customer wants to pay. They have that right to tell you where they want their funds to go. Now, the customer has a right to appropriate to a particular account to cover certain checks. However, where the customer does not specifically appropriate, the bank has the right to do so under the rule in Clayton's case. And this normally pertains to partnership accounts. So the rule in Clayton's case says that where a continuous running and unbroken account exists with payments, both in and out, in the absence of any instructions from the customer or the person making the deposit to appropriate monies paid in to a specific account or to cover any specific check, the credits are appropriated to the debits in date order where the account is overdrawn. If the account is in credit, then the debits extinguish the credits in date order. That's the rule in Clayton's case. Then they say that the rule itself can work to the detriment of the bank in certain instances. One could be receipt of notice of a subsequent mortgage when the bank is the first mortgagee and the customer's accounts are overdrawn on that date. Or if you have notice of death, mental incapacity, or bankruptcy of a joint account holder, where the joint and several liability has been established and the account is overdrawn. Or upon receipt of notice of mental incapacity or bankruptcy of the guarantor. Or when a guarantor gives notice to determine his or her guarantee. So to prevent the rule in Clayton's case operating to its detriment, what the bank normally does is it closes the account and opens a brand new account so they can stop the rule in Clayton's case being applied. The bank also has a right to combine accounts. So where a customer has two different accounts with the same bank, they can do so without giving any notice, even if the accounts are at different branches. So where there are 3 or more accounts, the bank has the discretion to combine any accounts of its choice. But there are limitations on the bank's right to combine. One is where the debit balance is on a loan account, which is presently due and payable. There is an implied agreement under the banker-customer contract to keep the accounts separate. 2, where the debit balance account is not yet a debt due and payable by the customer. A loan account which is payable at a future date cannot be combined, nor customer's potential liability as a guarantor. Any express agreement not to combine the accounts will prevent a bank from doing so. And fourthly, where one account represents funds held on trust by the customer, particularly where the bank knows that such funds are held on trust. So before we go into safe custody, I want you to look at the question I gave you on the motor company. The first one that you read, Doris. Five minutes. I want you to look at that case and then tell me how you're going to advise the motor company. Everybody has it, right?
Yes.
Okay, all right. Now, don't forget now, the approach that you're going to take to this is similar to the one that we did for David and Eric and the car. Send this to you all now. Let me know when you're ready. Whoever's the first one who wants to start, let me see.
Okay, so there was a fraudulent made, but Mr. Henry questioned it by calling not once but twice Mr. Ingram, and Mr. Ingram assured him that the check was authentic.
Mm-hmm.
But Mr. Ingram wasn't the one who signed the check. And they should have a specimen card to check. And if you had extreme doubt, then he should have reached out to Mistress Ingram, who was the one who supposedly had signed the check. So I think that's where he might have let the ball drop. Because I wouldn't know the other signatures.
Okay,
Why-
so
why
okay,
did-
so hold on now. So what you did first is you gave me your analysis.
Uh-huh.
Before you even write an analysis, you need to tell me what is the issue. What question are you trying to answer?
Okay, so the issue in this is that the issue is that Mr. Sands forged Mistress Ingram's signature. That's the brother-in-law, correct?
Hmm.
And the issue is that Mistress Ingram then felt that the bank didn't do its due diligence in avoiding any forgery on their particular account.
Okay, good. So now what's the law?
Okay,
What's the law?
So anyone can help you. What's the law?
What is the law? What is the law?
I keep Taurus,
but
why
don't laugh, Miss Archer, give me a minute.
I keep hearing her say, what is the law? Come on, let's go.
Okay,
3, 6, 8. I'm missing somebody off my list. Oh, let me see. Nabi, yeah, help her.
Nabi was
Latonya.
on.
Yeah, I know.
Nabi?
No, I sent in the other case. The one for next week.
Oh.
I just looking to see who I miss. Oh, yep, I see what I missed. They're looking right at me and I see it. PRIM. Ashley is who I was missing. Right. Okay, come on, what's the law?
I mean, as far as the duties of a bank or?
Yeah, it could either be the duty or the rights of a bank or the duties or the rights of the customer. So you have the question. Now tell me what the law is.
Know your customer?
Hmm? Okay, so start first. First is you have to deal with the bank. What was the bank's duty? The bank had a duty. What was its duty?
To ensure that no fraudulent activity took place, eh? To verify, right? To verify the signatures on the account to prevent forgery. Isn't that the bank's duty? To exercise due care and attention?
Exercise the proper skill and care in carrying out the customer's instructions, correct? Okay, so so you know that is the duty of the bank.
Right.
What's the duty of the customer in this same instance?
So reasonable care and drawing check
Okay,
to avoid
all right.
fraud or fraudulent or misleading the bank. But
Okay. And to advise the bank of any known forgeries.
and advise the bank of known forgeries. yeah.
Okay,
Right.
so now you've just stated what the law is, right? The case that you use for the
Yes, ma'am.
bank's duties and the customer's duties is the case of Johansson versus Swiss. So you stated what they are, but then you're gonna have to do a summary of what that case says.
Oh,
I sent you a link already. So you could try to answer this one, write it out too. So now let's go to the analysis. You already given me the analysis.
Mhm.
What did the bank do? The bank made its calls, It did his
Twice.
checks.
Yeah, but they didn't call the right person, eh?
That's what I trying to figure why he ain't talking to
Yeah,
Mr. Ingram.
Because only she could sign on this account.
Mhm.
So they failed to exercise duty and attention. They failed to verify with the account servicer.
Okay, so let's look at what it say. It say he was doubtful about the signature,
Mhm.
right? And then he called Mr. Ingram about the checks.
Yeah.
And he was assured by him that the checks were authorized by his wife and they could be paid.
but he didn't sign a contract on this account, this particular account, with the bank, so therefore he cannot speak to it. Only the person who signed on that account can speak to any transactions on that account,
Okay.
right?
And so where's your principle on that one?
He didn't actually do his due diligence.
No. You okay? You're talking about Mr. Ingram now, the husband. Correct?
Yes, yes.
Okay. So to bring that point in your analysis, you're gonna have to go back to the law. Was Mr. Ingram a party to the contract?
Yeah.
Yes.
No,
No.
Was he a party
No.
to the contract?
no, because it states only Mistress Ingram as the customer could sign and issue check. It's telling me, from this account. So only her one we have a contract with.
Okay. So you see how you start your question out. First, you have to establish who is the customer.
Mhm.
Then you have to establish the type of account that you have. This is a business account.
So,
We got to do different types of account later. So you have a business account and you have how many signatories?
one.
One. But who did the bank call?
A third party.
The bank or somebody has nothing to do with the account.
Agreed.
So that's the.
I'm just getting and I don't really get
Well,
glasses.
the bank will-
Ms. Archer?
Hmm?
So by calling the husband, that would be a breach of confidentiality.
be a confidentiality,
Mhm.
because that's another breach of contract that the bank
Mhm.
officer did. No?
Yes,
Oh, okay.
because he's not a signatory on the account.
Mhm.
Mhm.
And that's so presumptuous too. I mean, they might not even have been together, but I mean, that's, I'm just saying, you know.
Yeah. Mm-hmm. So there's another one for your homework. These are the kind of questions that you will see on your exams.
Mhm.
So you have to know the duties of a bank, the duties of a customer, the rights of a bank and the rights of a customer. And you have to know when the banker-customer relationship has been established and who has authority to do what on the account. So now let's turn to safe custody.
But I have a question. I mean, okay, so if this question is going to be presented like this and it says advise Bahama Bank. So we have to advise the bank on that.
At the very end, your last paragraph,
Uh-huh,
you will say whether or not, in your opinion,
uh-huh.
the bank breaches duties or
Okay.
the customer breaches duties.
Okay,
Or you may decide based on the scenario, you may say the bank had a right to do this. Or you may say the client had a right to do this. Or the bank did not have the right to do this.
okay.
Whenever you're talking about a bank and its rights and its duties, or its customers' rights and duties, you must mention the case of Jahimson versus Swiss.
Okay.
If it is a case where a customer is demanding their money, you're gonna reference the case of Jahimson versus Swiss, because you're gonna talk about the rights and duties of either parties. But you also have to establish that there's a debtor-creditor relationship. And that was established in the case of Foley versus Hill. And in this case, they found out later that the check was forged. And whenever there's a forgery, remember, the customer has a duty to inform the bank. And the case for that is Greenwood versus Martins.
Yeah.
Remember, the banking law cases you have to know.
So all of these
So-
cases,
No, not all. You'll
okay,
see that certain cases always come up. And those are the ones related to the rights and the duties on who is a customer,
okay,
because that's basic.
okay.
Now, the next area is safe custody.
Okay.
And whenever you put in something in safe custody, that falls under, in banking terms, under what we call bailment. So bailment is another contractual arrangement where one party holds or possesses the property for another in safe custody. So it's either for money or it could be free. And there are implied terms and conditions. So under the banker-customer contract, the customer is the bailor who deposits their items in safe custody under express and implied terms and conditions. The bailee, for which the terms must be returned to the bailor or dealt with according to his instructions. In bailment, the customer always retains the ownership of the items, always. So a bailee could be paid or he could be unpaid. The bank is always regarded as a bailee for reward because you have to pay in order to put something in safekeeping. So in the case of Port versus T.W. Wu, it established that the bank is always regarded as a bailee for reward when taking a customer's property for safe custody, whether or not it is specifically paid for the service. Now, under bailment, a bailee has a duty of care and conversion. So, and that duty of care means they could be liable for breach of contract if they negligently allow the items to be stolen or damaged, even if that person who did it is an employee. The bank could commit what we call a tort of conversion, where it refuses to deliver the property that's held in safekeeping to the customer upon his request or demand. Or if the bank delivers the property to the wrong or an unauthorized person, the client can sue the bank for tort of conversion. So even where it mistakenly hands over property to an unauthorized person based on forgery or mistake of fact, they can be sued for tort of conversion. So as a bailee for reward, which means that the bank is actually paid for their services, they have to take extra caution to ensure that the environment and surroundings where they keep their clients' items in safe custody is actually safe, that it is secure, and is inaccessible to unauthorized bank personnel. Any failure to keep these duty of care means that they can be sued for breach of duty to the customer. And then they can actually sue for damages or loss or theft or damage to property to safe custody. Goods that are held in safe custody cannot be used by the bank as a lien towards a loan. Because it doesn't fall under the ambit of the assets that the bank can actually have a lien against. A banker's lien is a special type of lien and is equivalent to an implied pledge and carries a power of sale. So when someone has something in safekeeping, the bank cannot take a lien against that item. A banker's lien gives the bank the right to sell whatever asset that it has a lien on, but not an asset that's in safe custody. So items that have been deposited for safe custody by 2 or more persons jointly, delivery of the item should only be made on authority of all of the bailors, not just one. It doesn't matter the relationship. The bank may take instructions from the joint bailors that any one of them may obtain receipt of the property once demanded. On the death of one of the joint bailors, the right of survivorship exists for the surviving bailor or his personal representative. So it's always recommended again that these arrangements are in writing. A bank can refuse to return items in safe custody on demand and detain the items for a reasonable time if it has some uncertainty or doubt as to the person who has ownership or title to the items in safe custody. Remember now, they can detain it for a reasonable time. A bank will only be liable for safe custody being stolen, lost, or damaged by its employees under the tort of vicarious liability. And that means that if the employee was acting in the course of his employment by performing his duties, even if he is doing so dishonestly, then the bank will be sued under vicarious liability because the employee was employed by the bank. It was a part of his job while he was doing it, and he stole or he lost the client's items that were in safekeeping. Usually a bank may not be held liable for theft by an employee where the employee was acting outside the scope of his employment or his duties and responsibilities. But again, it could be argued that the bank may still be liable for breach of contract for negligently permitting an unauthorized employee access to the items in safe custody, or again, being negligent because you have a dishonest employee. Now, customers who avail themselves of night safes are required to enter into an agreement with the bank, which provides that the relation of banker and customer does not arise until the wallet is opened. And customer in relation to the deposit meant until it's open, either by the customer or his agent or the bank on the customer's behalf, and deposited in the ordinary course of business. And is normally expressed in the agreement itself. Any questions on bailment? No? So in the case of Morris versus Martin and Sons, Morris had a mink coat dry clean, at which time the dry cleaner stole the coat. She sued, but the dry cleaner said they had taken all reasonable care to look after the coat and should not be held responsible. The issue is, could the dry cleaners be held responsible for the theft of an item by their staff? And the court held yes. From all these instances, we may deduce the general proposition that when a principal has in his charge the goods or belongings of another, in such circumstances that he is under duty to take all reasonable precautions to protect them from theft or depredation, that if he entrusts that duty to a servant or agent, he is answerable for the manner in which that servant or agent carries out his duty. If the servant or agent is careless so that they are stolen by a stranger, the master is liable, end quote. So how do you terminate a banker-customer relationship? The banker-customer relationship, as you all know, may survive indefinitely. only the banker customer contract may terminate. And it can terminate in 3 ways. 1, by the customer himself. The customer can come and demand full balance. He can withdraw all of his money and he can pay off all of his loans and terminate his relationship. Or the bank could decide to close an account. But of course, in closing an account, they have to give reasonable notice to the customer in order for them to make the whatever arrangements for their funds to be transferred. And notice the case again is Johansson versus Swiss. And you must give them reasonable notice. And the third way in which a relationship can be terminated, the contract, is by operation of law. And that's by death, that's by mental incapacity of the client, or bankruptcy or insolvency of the customer themselves. So I'm going to ask you some simple questions to wrap up. What is a banker-customer relationship? Any volunteers? Colette?
It's on both spectrum, a debtor-creditor relationship on both sides. The bank could be a debtor or the customer. The bank is a debtor through the deposits by the customer, and the customer can be a debtor through loans or overdraft facilities or such.
Okay, anybody wants to add?
They also have terms and conditions between both of them.
Yes. Anybody else? Okay, you said terms and conditions. Remember what I said? The first thing is a banker-customer relationship is contractual.
Right.
It's contractual and it's based in common law, case law.
Okay, that's what I missed.
And the contract imposes rights and duties on both parties, the customer and the bank. And there's an obligation, if it is not fulfilled, that either party may sue. Which case provides the foundation of the implied banker and customer duties?
Is it fully necessary?
No, that don't give you duties. Foley versus Hill establishes that there's a debtor-creditor relationship between the bank and its client.
Also Johansson versus
Johansson
Swiss.
Johansson
Right.
versus Swiss. Yeah. That gives you the foundation of the implied banker and customer duties. And remember now, in this modern day, because that was done in 1921, in this modern day, a lot of those implied banker and customer duties are actually expressed in the banker customer contractual arrangement. So next week, I'm going to ask you all, what are the banker's duties, which you should know? What are the customer's duties? Again, what are the banker's rights? What are the customer's rights? And then we'll go on to confidentiality, which is the next topic, which is a duty of the bank. Any questions?
Yes.
You have
the-
2 sets of homework to do.
Oh.
Yes, the
Did
2
you-
questions you're gonna try. Someone's going to say something.
Yeah, I was gonna. You can go ahead.
I was asking if she already said the homework.
Yeah, that's what I was.
Yeah, you have it already.
Okay.
The same questions that I sent you, you need to now answer it. Write it out.
Oh, Jesus.
Yes. It's practice for the midterm. You know, the midterm is coming up very soon.
Yes, ma'am.
You meant for David and Ingram?
Yes, those
Okay.
two.
Okay.
And remember, for the midterm, I'm going to give you one like David and Eric, but you will do that at home and email it to me because you'll use the case laws. But when you come to do the midterm, you'll have banking law cases and there will be no cases for you to turn. They must be in your head.
Can I
So you
use
have
your
to-
head?
No, you can't use my head. You got to use your head. And I'll tell you one of the normal things, the typical things I see in the midterm, and even when it comes to the final, because these rights and duties, and when someone is a customer, have to always be at the back of your mind when you're answering a banking law question. And students tend to forget that you have to know the difference between the banks and the customers' rights or duties. Once you start mixing them up, it's obvious you don't know. So what you want to do now is summarize them, put them on a card. One says bank and one says customers. And you need to know it out of your head.
Okay.
Because otherwise you're gonna get all mixed up. Okay? Any more questions? Okay, so on Monday, we're gonna do the duty of confidentiality.
And it'll be Monday.
When you,
You still have school Monday?
Monday,
I think
darling.
you mean Wednesday.
I mean, Wednesday.
Oh,
I keep forgetting. The case, let me hit send. It's gone. Everybody should have it. Let me know if you didn't get it.
Yeah, I got it. Nabi got
Okay.
it.
All right, let me make sure I have everybody here for the roster for school. I have Doris, Colette, Branique, McQuell, Waltine, Tia, Ashley. That's everybody, right?
okay, yeah, I got it. Okay,
I didn't
got
miss
it.
anybody, right?
No.
Okay.
We got Nikiva. I know you said Nikiva.
No, I did not say McKeever.
Nikiva.
Nikki, yeah, I know. When we were
Okay.
calling you, you weren't on yet.
Oh,
I got you.
okay.
I got you. I got you.
Okay.
Okay. Everybody's good now, right? Huh?
79 pages.
Yeah, I told you it's very long. So you have enough time to read it because Monday's a holiday. Thanks for reminding me.
Well, if you're busy,
Busy doing what?
send Jesus to help us.
No, you don't need to come help you all. You could do this.
What are we doing
You-
again?
You are attempting to answer the question on David, attempting to answer the question on Ingram. Being mindful that when you answer the question on David, there's a link I gave you to cases.
Uh-huh.
When you get your midterm take home, one question, you could use those cases in that link.
Okay.
Send it to me on the day of the midterm, or you could send it the day after, but I must have it by Friday.
Okay. Okay.
Because I'm gonna mark them on the weekend, that weekend.
That's long. We reading
No,
all
it's
of this?
not.
And it's midterm.
Stay focused, stay focused, stay focused. The midterm is July the 21st. That is a Wednesday.
Okay.
You said we
So you
reading
have
all of
until
this?
that Friday to send it to me.
Wow. Okay.
Yeah.
So if you make your attempt and I look at it on Wednesday, I can actually send you the contract case next week, Thursday. So you'll have almost a week to do it.
What? I confused. Hold on.
Okay. Next week, Wednesday is July the 14th. Agreed?
Mm-hmm.
Our next class is next week, Wednesday. That's the 14th. If I have your drafts, we can discuss those on Wednesday, the 14th.
Okay, mean drafts of these two cases.
Yes,
homework.
the two homework,
Okay.
right. I can tell you where you're going right, where you're going wrong, what you miss. No,
Okay.
it's not clear. Okay. On the
Alright.
15th, the next day, I can send you that one contract question that you need to do for your midterm.
Okay, okay.
And you turn it in either on the day of the exam, which is the 21st of July, the following Wednesday, or you can give it to me, send it to me by the Friday of the same week.
If we send it by Friday, can we do, can we edit it if we send it before midterm?
No,
Okay.
no. That's why it's that question for you is an open book. So if you attempt the homework, you'll have an idea whether or not what you was thinking was right. You should be able to do it.
Okay. So the homework is just like a warm up, like a practice.
Yes, yes. So if you don't do it, and then I send it to you, the homework question, and then if you get it wrong, what can I say? If you didn't try it,
Yeah.
to make sure you know what you're talking about. And then the same thing for the banking law one. Because when you go in an exam, you're not going to have any cases in front of you. You're going to have to know which cases go with what. And so the only way you could do it is to try to apply it now. So when you get in an exam for the midterm, you don't start to panic.
Hi.
Go ahead.
I think I was late, right? But I'm missing something.
What's that? What
I
you
don't
missing?
know. So you send a question first answer. You say?
What you mean for homework?
Yeah.
It's in the email.
You sent it to us already.
Yeah.
So at the top on it to download. That's what I'm looking at.
What you have? It's long.
It's long, yeah.
Mm-hmm.
You say we
So it's the one that says
answer?
David. That's the first one. You see it?
Darren, okay.
No, David.
David.
Uh-huh. And then the next email was some contract cases. It says
Mhm.
law teacher.
Mm-hmm.
Okay. The next second question that you're going to practice is the one with the Ingram,
Mm-hmm.
which is a banker customer relationship. The next link is Johansson versus Swiss, which is the foundation for the implied banker customer relationship, duties and rights. And then the last one is the document I sent for you to read for next Wednesday, which is the local case that was just tried by a client suing the bank.
Okay.
So on your calendar, you put 21st of July midterm
Okay.
in class.
Oh. Okay.
21st of July.
Okay.
And then you could put the 15th of July. Take home contract question for midterm.
Mm-hmm.
Due by the 23rd of July.
Okay.
The final exam is August the 18th. And you all have agreed, no research question. Ah!
Mm.
Agreed?
Mm. Yep.
All right. So you have Monday off. You could read the case of Jahimson versus Swiss. You can read the case of Pinder versus Scotiabank, and you could do your 2 questions. So when we come on Wednesday, I'll be there early from 5:30. We could start. All right.
Okay.
Okay.
Sounds good to everybody?
Yeah. Sounds
I ain't
fabulous.
hearing much.
Yes.
Yeah.
Okay. So have a good holiday. Work hard, get a nice glass of wine, and read my cases.
All right.
Okay?
Okay.
All right.
Yes, ma'am.
All right.
Okay, good night.
Good night.
Good night.
Okay.